So we go to topic 2, which is why I've come here. Death penalty, right? I don't know how much you as a university, how familiar you are with the progress of the law as far as death penalty is concerned. I do know, and I've closely associated myself with their work, the National Law University, Delhi, has a death project, and their students have gone to prisons, have interviewed prisoners on death row under the guidance of their professor, Dr. Anup Surendranath, who was one of the petitioners in the Yakub Memon case. I am not going to be talking about the validity of the death penalty, about the morality of the death penalty, about the legality of having a provision which almost 2/3 of the countries in the world have abolished. That's not the intent of this lecture. I am talking about the development of the law in this field, assuming that since the death penalty is on our statute book for some offenses, so clearly it's legal, but how must the death penalty be imposed in cases? What is this rarest of rare formulation that we've developed? What are the cases that come within that formulation? Is there a straitjacket formula, or is that a flexible formulation? Have the recent decisions of the Supreme Court taken note of those formulations, etc.? So the development and the evolution of the law, starting with the Constitution Bench judgment of 1980, to the dip that took place in the Supreme Court in the 1990s, to the reassertion of the constitutional position in the 2000s, and now a further dip taken in the Yakub Memon case. So I am only tracing the evolution of the law. I hope at some stage you people get to read these judgments, because it's important to know in today's context what constitutes rarest of rare, in what case will you award the death penalty, in what case will you fail to award the death penalty. The truth of the matter is, I don't think anyone knows, including the Supreme Court. But over a period of time, pending the debate whether we should have death penalty in our statute book, what has happened is that the Supreme Court has attempted to lay down a law to restrict the use of the death penalty to those gross cases where, in their words, the option of life has been irrevocably closed. Right? The words they use is, death penalty will be imposed only in those cases where the option for life has been irrevocably closed. So it's a very interesting area of the law where there has been much development, some regression, and much development after the regression. So I'll just trace, I mean there are millions of judgments, but I'll just trace and flag the landmark judgments which I would want you as students of the law to read. It's a very, very interesting, very, very emotive issue, and it's important as students of the law to understand both the legality and the emotions behind the issue. So I'll start with the first really meaningful judgment on the point, which is, and if you want to take down the citation, 1980, Volume 2, SCC 684, Bachan Singh versus State of Punjab. It is a Constitution Bench judgment of the Supreme Court and is the law of the land, because it has not been diluted, improved, negated by a higher bench strength, therefore is the law of the land. Now, in Bachan Singh's case, the constitutionality of the death penalty was challenged both on substantive as well as procedural grounds. A five-member bench of the Supreme Court held that the death penalty passes constitutional muster on substantive grounds, but as far as the procedural grounds were concerned, now there is a provision of law I want you to read, and that is section 354. The procedural challenge was that the sentencing regime under Section 354, subclause 3, invests courts with arbitrary powers, and therefore there was need to limit the application of that arbitrary power. Now let's read subclause 3. When the conviction is for an offense punishable with death, or in the alternative with imprisonment for life, or imprisonment for a term of years, the judgment shall state the reasons for the sentence awarded, and in the case of the sentence of death, the special reasons for such sentence. The important two words here are special reasons. What was discussed and what has been a matter of concern for jurists has been what constitutes these special reasons, because it's very freakishly applied. And is there any way in which we can provide guidelines for the just application of this provision in the context of the sentence of death penalty? Now, if you were to read Bachan Singh's case, in the SCC citation, I'm referring to 3 paragraphs. You have to read the whole judgment. Essentially 3 or 4 paragraphs. Para 161, para 197, paras 202 and 203, and para 209. Remember, this is the Constitution Bench judgment of the Supreme Court. This is the law of the land. Now, para 161, and I'll read that to you. Just hear me out. A study of the propositions set out above will show that in substance the authority of none of them has been affected by the legislative changes since the decision in Jagmohan's case. Of course, 2 of them require to be adjusted and attuned to the shift in the legislative policy. The first of these propositions is which postulates that according to them, extant a Code of Criminal Procedure, both the alternative sentences provided in Section 302 CRPC are normal sentences, and the court can therefore, after weighing the aggravating and mitigating circumstances of the particular case in its discretion, impose either of those sentences. This postulate has now been modified by Section 354, subclause 3, which mandates the court convicting a person for an offense punishable with death, or in the alternative with imprisonment for life, or imprisonment for a term of years not to impose the sentence of death on that person, unless there are special reasons to be recorded for such sentence. The expression special reasons in the context of this provision obviously means exceptional reasons, founded on the exceptionally grave circumstances of the particular case relating to the crime as well as the criminal. Thus, the legislative policy now, writ large and clear on the face of Section 354(3), is that on the conviction for murder and other capital offences punishable in the alternative with death under the Indian Penal Code, the extreme penalty should be imposed only in extreme cases. I'll stop here. See, the law of the land from the beginning has been, even before the Bachan Singh verdict, has been when you award death penalty, you should make a set of aggravating circumstances, a set of mitigating circumstances, and do a balancing act. If the aggravating circumstances far exceed the mitigating circumstances, award death penalty. If the mitigating circumstances far exceed the aggravating circumstances, don't award death penalty. Now, that was a law till the 1980 judgment. Not that that law has been wholly disregarded. But what the Supreme Court did in Bachan Singh's case was to add additional caveats to that law of aggravating versus mitigating circumstances. What is the caveat they added in this case? They said, when you're looking at aggravating and mitigating circumstances, you're looking at aggravating and mitigating circumstances of the crime. We are now asking you to look at aggravating and mitigating circumstances of the criminal as well before you decide to award the death sentence. So this was a very, very important landmark shift in sentencing which came about in Bachan Singh's case. Look at aggravating and mitigating circumstances, but circumstances of the crime as well as circumstances of the criminal. And only when you do a combination of both, can you arrive at a finding whether the death penalty is warranted in a particular case or not. What the Supreme Court essentially did was further compress the areas where death penalty could be handed out. Make it very difficult to award the death penalty, because you not only had to do a compilation of the aggravating and mitigating circumstances of the crime, you also had to do the aggravating and mitigating circumstances of the criminal. Now, what are the aggravating and mitigating circumstances you can ask of the criminal? Several. Age of the criminal. And the most important, actually, is the possibility of reform. Remember the essence of law. The essence of law, and particularly criminal law, the essence of sentencing and punishment is the possibility of reform. Punishment not seen as an element of revenge, but punishment seen in the reformative way. That's how progressive societies look at punishment. So, at the end of a trial, you justly punish a person for the crime he's committed. But at what point do you stop? At what point do you say that the option of life is irrevocably foreclosed for this man or woman? For that, you have to consider the aggravating and mitigating circumstances of the criminal as well. And I will now, through this address, show to you how wrong the Supreme Court was in the Yakub Memon case, and for reasons that we will now examine. So this was para 161. What the Supreme Court said was, death to be imposed only in extreme cases and not otherwise. If we were to go to para 197, it's even more beautiful. What the Supreme Court, it's kind of strange to say it's beautiful when you're dealing with death sentence. Anyway, in Jagmohan, this court has held that this sentencing discretion is to be exercised judicially on well-recognized principles after balancing all the aggravating and mitigating circumstances of the crime. Now, this was pre-Bachan Singh. By well-recognized principles, the court obviously meant the principles crystallized by judicial decisions, illustrating as to what were regarded as aggravating or mitigating circumstances in those cases. The legislative changes since Jagmohan have been discussed already, do not have the effect of abrogating or nullifying those principles. The only effect is that the application of those principles is now to be guided by the paramount beacons of legislative policy discernible from section 354(3), namely, the extreme penalty can be inflicted only in gravest cases of extreme culpability, in making the choice of the sentence, in addition to the circumstances of the offense, due regard must be paid to the circumstances of the offender also. So have you seen how the law has evolved? So pre-1980, we had a system of aggravating versus mitigating, but only confined to circumstances of the offense. Post-1980, with the Constitution Bench judgment, we are now told that when you're dealing with aggravating and mitigating, you also have to go and look at the circumstances of the offender. Very, very important departure, an extremely important evolution of the law brought about by Bachan Singh's case. In paragraph 202, the Supreme Court has taken note of some Lok Sabha and Rajya Sabha debates and some suggestions by Dr. Chitle about what would constitute aggravating circumstances, including if the murder has been committed after previous planning, extreme brutality, exceptional depravity, if a member of an armed force or the union or member of the police force has committed the crime while on duty, etc., etc. So though they've made it very clear that these are just examples. We don't want to make these as the only circumstances pertaining to aggravating circumstances. But what is really, really, likewise in paragraph 206, they talk of some possible mitigating circumstances, but they make it clear, this is not a tight jacket formula, and you can either go beyond it, and every case has to be decided on its own merits. 209, paragraph 209 is very important, where they say, there are numerous other circumstances justifying the passing of the lighter sentence, as there are countervailing circumstances of aggravation. We cannot obviously feed into a judicial computer all such situations, since there are imponderables in the imperfect and undulating society. Nonetheless, it cannot be overemphasized that the scope and concept of mitigating factors in the area of death penalty must receive a liberal and expansive construction by the courts in accordance with the sentencing policy writ large in section 354(3). Judges should never be bloodthirsty. How nice. Hanging of murderers has never been too good for them. I wish they read their own judgments. Facts and figures, albeit incomplete, furnished by the Union of India, saw that in the past, courts have inflicted the extreme penalty with extreme infrequency, a fact which attests to the caution and compassion which they always brought to bear on the exercise of their sentencing discretion in so grave a matter. It is therefore imperative to voice the concern that courts, aided by the broad illustrative guidelines indicated by us, will discharge the onerous function with ever more scrupulous care and humane concern, directed along the high road of legislative policy outlined in section 354(3), namely that for a person convicted of murder, life imprisonment is a rule and death sentence an exception. A real and abiding concern for the dignity of human life postulates resistance to taking a life through law's instrumentality. That ought not to be done, save in the rarest of rare case, when the alternative option is unquestionably foreclosed. Can it be clearer than that? And can it be written in a more beautiful, lucid fashion than it was done in 1980? So where do we lose our way? We lost it quite soon, actually, in 1983. And that is the judgment of Machi Singh and others versus State of Punjab, 1983, volume 3, SCC, page 470. Remember, Bachan Singh was a constitution bench judgment of 5 judges. Machi Singh is a 3-member bench and had no business doing what it ultimately did. But that's the Supreme Court for you. Now, what actually happened? Machi Singh is actually a complicated case. The facts are horrendous. But what they did was, and the important paras which you must read, the one singular para which you must read is para 33 in the SEC citation. What it did in Machi Singh's case, but what the Supreme Court deliberately did not do in Bachan Singh's case, advisedly, deliberately, consciously, they said, these examples we're giving are purely illustrative. They are not guidelines that you have to tick off while deciding to give somebody death penalty or life imprisonment. What Machi Singh did was, unfortunately, in paragraph in its judgment, in paragraph 33, it expanded the scope of Bachan Singh by itemizing those aggravating circumstances it considered necessary for purposes of awarding death. What were those? Manner of commission of murder, motive for commission of murder, antisocial or socially abhorrent nature of the crime, magnitude of crime, personality of victim of murder. They introduced these 5 elements to the aggravating circumstances, which then for a while took over the judicial discourse and the judicial narrative. And in a strange way, they attributed these 5 aggravating circumstances to Bachan Singh's case, when Bachan Singh had studiously stayed away from doing that. It is therefore the opinion of jurists that Machi Singh versus State of Punjab was per incurium, and it took us some 20 years to come to that conclusion after, unfortunately, 6 rather tragic executions. What Machi Singh also did, in direct contravention to the Supreme Court judgment of Bachan Singh, was limit the circumstances to the circumstances of the crime. It obliterated the expansion of the scope given in Bachan Singh, where they said, go beyond the circumstances of the crime, go to the circumstances of the criminal. Machi Singh failed to take into account the aggravating and mitigating circumstances of the criminal. And in that respect, a 3-member bench completely and totally, in a matter of gross judicial impropriety, diminished the verdict of Bachan Singh versus State of Punjab. So this happened in 1993. Several things happened afterwards, but several judgments took place afterwards. But the highlight of the law, of the progress or evolution of the law, took place in 1996. 1996, Volume 2, SCC, page 175, Ravji alias Ramchandar versus State of Rajasthan. This was the particular law. This judgment constitutes the lowest of the low that the Supreme Court fell to by not only not following Bachan Singh, but even mitigating the circumstances of Machi Singh. Now, what the Supreme Court, a 2-member bench, a further departure from Bachan Singh. Again, the facts of the case are gross. This man is supposed to have killed his wife and 3 children. What they did, however, while discussing sentencing, in the last paragraph, you can read paragraph 24 of the judgment. What it did was, it put this one line, which became very problematic for everybody later on. It said, it is the nature and gravity of the crime, but not the criminal, which are germane for consideration of appropriate punishment in a criminal trial. Are you seeing how judgments are diminished by the same court which passes the judgment in the first place? Bachan Singh says that the punishment must take into account the circumstances of the criminal. A 2-member bench of the Supreme Court says it is the nature and gravity of the crime, but not the criminal, which are germane for consideration of appropriate punishment in a criminal trial. Total and complete abuse of the Constitution Bench judgment of the Supreme Court by the Supreme Court itself. Mercifully, in 2009, again a 2-member bench, 2009, Volume 6, SCC 498. This is a case of Santosh Kumar versus State of Maharashtra. Held the 1996 judgment and all the intervening judgments to be per incurium, not having followed the judgment of the Supreme Court laid down in Bachan Singh versus State, and tried to re-establish the position through this judgment of Bachan Singh versus State. In this, I'd like you to flag paragraphs 62, 63, 64, 89, and 172. What is paragraph 62? I'll read that for you. Curiously, in Ravji versus State of Rajasthan, that's the judgment where, the judgment that I just read, where the Supreme Court said it is the nature and gravity of the crime, but not the criminal, which are germane. So the Supreme Court is re-examining that case. Curiously, in Ravji versus State of Rajasthan, this court held that it is only the characteristics relating to crime to the exclusion of the ones relating to the criminal, which are relevant to sentencing criminal trial, stating the crimes have been committed with utmost cruelty and brutality without any provocation in a calculated manner. It is the nature and gravity of the crime, but not the criminal, which are germane for consideration of appropriate punishment in a criminal trial. Now, para 63. We are not oblivious that Ravji's case has been followed in at least 6 decisions of this court in which death penalty has been awarded in the last 9 years. But in our opinion, it was rendered per incuriam. Bachan Singh specifically noted the following on this point. The present legislative policy discernible from section 254(3) is that in fixing the degree of punishment or making the choice of sentence for various offences, including one under section 302 of the Penal Code, the court should not confine its consideration principally or merely to the circumstances connected with a particular crime, but also give due consideration to the circumstances of the criminal. Shivaji versus State of Maharashtra, Mohananna Chavan versus State of Maharashtra, Bantu versus State of UP, Surjaram versus State of Rajasthan, Dayanadi Bisoi versus State of Orissa, and State of UP versus Satan are the decisions which Ravji has been followed. It does not appear that this court has considered any mitigating circumstance or a circumstance relating to the criminal at the sentencing phase in all these cases. It is apparent that Ravji has not only been considered, but also relied upon as an authority in the point that in heinous crimes, circumstances relating to criminal are not pertinent. Para 64. Another aspect of the rarest of rare doctrine which needs serious consideration is interpretation of the latter part of the dictum, para 751, para 209, that ought not to be done save in the rarest of rare case where the alternative option is unquestionably foreclosed. Bachan Singh's suggested selection of death penalty as a penalty of last resort when alternative punishment of life imprisonment will be futile and serves no process. So in 7 cases, people were handed out the death sentence by the Supreme Court because they failed to read their own judgment, the Constitution Bench judgment of Bachan Singh versus State. Can there be a grosser transgression of the law than that? Coming from the highest court of the land. And this case, Santosh Kumar versus State of Maharashtra, takes that into account and speaks of that with much anguish. We now come to paragraph 89. After declaring all those judgments to be per incuriam and re-establishing the primacy of Bachan Singh, Justice Sinha wrote, capital sentencing is one field where the safeguards continuously take strength from the Constitution. And on that end, we are of the view that now this is very important, that public opinion does not have any role to play. In fact, the case where there is overwhelming public opinion favoring death penalty would be an acid test of the constitutional propriety of capital sentencing process. So this nonsense that we hear on television every day about closure, whatever that loathsome word means, closure to the victims, that is not to be taken into account when the judge sits at the time of sentencing, and this judgment says that even when there is overwhelming public opinion favoring death penalty, that's the case where the acid test of constitutional propriety of the capital sentencing process begins. So look at it in the context of what is happening today, the circumstances that are being put forth as arguments to hang a man. When the Supreme Court itself says that capital punishment is one field where the safeguard continuously are taken from the Constitution of India, and public opinion has no role to play while we decide sentencing. So a word which was developed subsequently to hang Afzal Guru to satisfy our collective consciousness was not something that either the Constitution Bench judgment of the Supreme Court or this judgment of the Supreme Court approved of. Because, as they say, public opinion is irrelevant. This is a court of law. This is not a court of public opinion. This is not the NDTV studios. In a court of law, you have to follow the parameters of the law or the law laid down by the Supreme Court. And you cannot be overwhelmed by the opinion which is being assiduously developed by vested interests for particular reasons. You have to look at the circumstances of the crime and the circumstances of the criminal. Public opinion has no role to play at all. I am not saying it, the Supreme Court is saying it. Now, para 172 of the very same judgment. Actually, before para 172, it is in para 134, this judgment has again reiterated the rarest of rare formula by reiterating what Bachan Singh said, that the rarest of rare formula, a real and abiding concern for the dignity of human life, postulates resistance to taking a life through law's instrumentality that ought not to be done save in the rarest of rare cases when the alternative option is unquestionably foreclosed. They have then gone through many jurisprudence across the world, and in the last paragraph, para 172, they say, we have previously noted that judicial principles for imposition of death penalty are far from being uniform. Without going into the merits and demerits of such discretion and subjectivity, we must nevertheless reiterate the basic principle stated repeatedly by this court, that life imprisonment is a rule, death penalty an exception. Each case must therefore be analyzed and the appropriateness of punishment determined on a case-by-case basis, with death sentence not to be awarded save in the rarest of rare case where reform is not possible. Keeping in mind at least this principle, we do not think any of the factors in the present case discussed above warrants the award of the death penalty. There are no special reasons to record the death penalty, and the mitigating factors in the present case discussed previously are, in our opinion, sufficient to place it out of the rarest of rare category. Now, if you were following the Yakub Memon case, particularly the last week of July, which caused many of us much anxiety and sleepless nights, including the Supreme Court. That was the only positive thing that came out of that whole exercise. We woke them up at 3 o'clock. There was much discussion, both in the media, it was also argued in court, about the guidelines, and I just thought this would be of interest to you, and that's why I'm referring to that judgment, about the guidelines. There was this discussion about the 14-day rule, that once the death warrant has been signed and the mercy petition has been dismissed by the president or the governor, as the case may be, and all options, legal or otherwise, have been completely closed, do you execute it in the next hour, or do you give him some time? Now, that was discussed in a 3-member bench judgment of the Supreme Court, citation 2014, volume 3, SCC, page 1, Shatrughan Chauhan and another versus Union of India. I will be referring to paras 14, 45, 55, and 241, as well as 64. I mean, you can read these paragraphs, but essentially, what the Supreme Court has, the guidelines given by the Supreme Court, is contained in para 241. So what the Supreme Court says is that once the mercy petition has been rejected by the president, once all legal options have been closed, and what remains is the spectacle of hanging, what do you do? 241.1 says, no, one second, I'll just give it to you. It's not in 241, 241.7 says minimum 14 days notice for execution. Prison manuals do not provide for any minimum period between the rejection of the mercy petition being communicated to the prisoner and his family and the scheduled date of execution. Some prison manuals have a minimum period of 1 day, others have a minimum period of 14 days. It is necessary that a minimum period of 14 days be stipulated between the receipt of communication of the rejection of the mercy petition and the scheduled date of execution for the following reasons. A, it allows the prisoner to prepare himself mentally for execution, to make his peace with God, prepare his will, and settle other earthly affairs. B, It allows the prisoner to have a last and final meeting with his family members. It allows the prisoner's family members to make arrangements to travel to the prison, which may be located at a distant place, and meet the prisoner for the last time. Without sufficient notice of the scheduled date of execution, the prisoner's right to avail of judicial remedies will be thwarted, and they will be prevented from having a last and final meeting with their families. Now, besides these, the Supreme Court actually gave other guidelines and other important safeguards. One was solitary confinement. This court in Sunil Batra held that solitary or single cell confinement prior to the rejection of the mercy petition by the President is unconstitutional. Almost all prison manuals of states provide necessary rules governing the confinement of death convicts. The rules should not be interpreted to run counter to the ruling and violate Article 21 of the Constitution. So if the prisoner is put in solitary confinement prior to his death sentence, to his mercy petition being rejected, that has been termed as unconstitutional. Second, legal aid. The Supreme Court needs to be satisfied that till the very end, the prisoner had access to justice. Three, procedure in placing the mercy petition before the President, certain guidelines were framed. No prison manual has any provision for informing the prisoner of his family of the rejection of the mercy petition by the governor, since the convict has a constitutional right under Article 161 of the Constitution to make a mercy petition to the governor. He is entitled to be informed in writing of the decision on that mercy petition. The rejection of the mercy petition by the governor should forthwith be communicated to the convict and his family in writing or through some other mode of communication available. Likewise, Article 72 gives you prescribes the right to the prisoner to make a mercy petition to the President of India. Even there, the Supreme Court said that if his mercy petition under Article 72 is being rejected, a communication in writing must be forwarded to him. Death convicts are entitled as a right to receive a copy of the rejection of the mercy petition by the President and the governor. Then they talk of the 14-day period. Communication to family members. It is the obligation of the superintendent of jail to see that the family members of the convict receive the message of communication of rejection of mercy petition in time. Next, mental health evaluation. This was again a gross violation in the Yakub Memon case because they asked for a mental health. The man was suffering from schizophrenia, not allowed. We have seen that in some cases, death row convicts lost their mental balance on account of prolonged anxiety and suffering experienced on death row. There should therefore be regular mental health evaluation of all death row convicts, and appropriate medical care should be given. Physical and mental health reports, furnishing documents to the convict, a final meeting between prisoners and his family, and then post-execution, his post-mortem report must be handed over to the members of his family. So Shatrughan Chauhan's judgment is relevant because in para 64, it again reiterated Bachan Singh and said, gravity of the crime, cruelty and horrible consequences to society are not relevant after Bachan Singh. It upheld Bachan Singh, but additionally it's relevant because it placed certain guidelines during this whole process of mercy petition and rejection of mercy petition, which must be followed with in the case of a death row prisoner. I will also refer to a judgment of the Delhi High Court. If you were to go to SCC Online, this is 2014 SCC Online Delhi 2225. It's a very, very interesting judgment by Justice S. Muralidhar and Justice Mukta Gupta, in which, following Bachan Singh and some of the more liberal judgments after that, the court held an evidentiary hearing with respect to formulating the mitigating circumstances, both of the crime as well as the criminal. And the court asked for a probation officer's report where it specifically asked two questions. In paragraph 3 it says, this led the court in its judgment dated so and so to call for a report of the probation officer on the following two aspects. One, is there a possibility that in the future the accused would commit criminal acts of violence as would constitute a continuing threat to society? Is there a probability that the accused can be reformed and rehabilitated? The probation officer, after conducting a detailed psychological examination of the convict, answered in the negative, with respect to both these questions, saying there is no apparent probability that he would commit this crime in future, and there is every probability that the accused can be reformed and rehabilitated. Based on that, on its own evidentiary hearing and on the probation officer's report, the High Court proceeded to state, in view of the above, there is nothing to suggest that the index client cannot be reformed and reintegrated and the reformative process through social correctional measures, and it finally proceeded to commute the death sentence into life. In the light of the above, court is persuaded to conclude there exists a probability that the appellant can be reformed and rehabilitated. The appellant has been in custody since such and such date. In the course of his serving imprisonment for life, there should be sufficient opportunity to evaluate the positive effects of the correctional measures. His continued incarceration would ensure that he would not commit criminal acts as would constitute a continuous threat to society. Consequently, the court declines to confirm the death sentence recommended to be awarded to the appellant by the trial court, and instead commuted the death sentence to life imprisonment. So these are the developments of the law. I have, in a 1,000-page judgment of no consequence, pulled out 3 pages in the Yakub Memon case. Just look at the way, the casual way in which sentencing was dealt with by the Supreme Court in para 873 of the judgment. It's actually 2013, volume 13 SEC. I'm not sure of the page number. You can find that out. Thus, the 2 cardinal factors, namely, 1, the penalty imposed must be proportionate to the gravity of the crime. 2nd, the degree of responsibility of the offender must be, whatever that means, the degree of responsibility of the offender must be taken into account in determining the sentence for an individual accused, in addition to the aggravating and mitigating circumstances. Bas. Death sentence upheld. 1 paragraph. So, and while we're doing that, I'll just discuss a little about the Yakub Memon case. Gone, but we can still review it. What was the nature of evidence against him? Purely circumstantial. Confessional evidence of the co-accused. Some of you may not know it, but some of us did follow this case. So there was much debate in the media whether Raman's article was true, not true, or actually it was true, and much, much more was true. The fact of the matter is that the Indian intelligence agencies were in direct communication with Yakub because they knew that Yakub was very unhappy with the manner in which he was placed in Pakistan. He wanted to return to India. He came to Nepal with all those fabricated passports. He wouldn't have come to Nepal with his Indian passport, Pakistani passport, Dubai visa, Hong Kong visa, if he did not want to surrender. And not only that, he brought back all members of his family as promised. Not only that, he gave information. The Indian intelligence agencies pretend they are better than the best in the world. Actually, they're quite useless. We all know that. They are never able to unearth any conspiracy unless you hand it over to them in a platter. Yakub Memon handed it over to them on a platter. It is then that they were able to locate the exact location of Mahmoud Ibrahim. It was then that they were able to locate the exact house and location of Tiger Memon through the photographs, video clippings, and other evidence, including voice recordings that Yakub had clandestinely taken while he was in Pakistan of these other men. The volume of information that he gave was unprecedented. After that, after bringing him into this country, and I'll tell you one more, across the globe, investigators they showed this fraudulent arrest in New Delhi railway station. All of which he went, he allowed himself to be subjected to that. His wife, his mother, his sisters, everybody came after that from Dubai. Initially, they weren't even opposing his bail application. The approver, whose evidence was being recorded in the special court in Mumbai, had till that time not even named Yakub. But then came the deviousness of the state agencies. Ab mil gaya, to isi ko marte hain. So what do? They shifted the narrative. Since they were not likely in their lifetime to ever get Babu Ibrahim or Tiger Memon, they decided this is the fall guy we want. So he's given everything he needed to give to us. He's foolish enough to listen to our promise. So be it. Now let's now turn the case and place all the blame. Midway through his statement in court, the approver changed tack. And you know exactly when he did it. After Yakub was brought into the country. Now, surely all of this, in a fair world, would constitute mitigating circumstances of the criminal. Particularly when there is no direct evidence to suggest that he planted any bomb, that he was involved in any way with the conspiracy of planting the bomb, other than the confessional statements of co-accused persons recorded subsequent to his arrival in India, which they subsequently retried. We all know how confessional statements are recorded in our country. I have great respect for law enforcement. I think of myself as a law-abiding citizen of this country, but I also know that the one agency which is by and large not law-abiding are investigating agencies. So confessions are always thrust on people. When they were retracted, and how did it happen? TADA was in force at that time. Under TADA, confessional statements, because under the Evidence Act, a confessional statement has no bearing. You have read sections 25, 26, 27 of the Indian Evidence Act, or maybe you haven't, I don't know. But under the Evidence Act, confessional statements cannot be used in evidence. Under TADA, it was admissible in evidence. And through that tenuous process, and in the circumstances that I mentioned, those confessional statements were made against Yakub, and the Supreme Court in its judgment does say, A1 is the younger brother of Tiger Memon, uski kya galti thi agar if he was a younger brother, who is one of the masterminds behind the blast. A1 was in a position of authority, sometimes I think, am I reading the Supreme Court or some class 3 student? A1 was in a position of an authority particularly, and had played a significant role in the context of the blast, which is important while determining the sentence. The confessional statements of the co-accused discussed in the earlier part of the judgment under A1's appeal established the dominating position of the appellant in comparison with the other 10 appellants. The other 10 appellants actually planted the bombs. They actually executed the whole thing. Unko to chhod diya. Because they didn't have a brother called Tiger Memon. Very simple logic. But Yakub, somebody has to pay for this. You see, the state has to be seen as very strong. We have to tell the world we have zero tolerance against terror. It doesn't matter who we are killing, but we have to tell the world that. So, the judiciary, I'm sorry to say, also becomes complicit while furthering the state's agenda. There is no discussion on aggravating, mitigating circumstances. There is an admission that the only evidence against him is the confessional statement of the co-accused and nothing beyond that. And yet, you proceed to execute a man who was convicted 12 years ago and sentenced 12 years ago, and since then has added another 8 years on death row, has been in custody for 20 years. Was the option of life unquestionably foreclosed in this case? I am asking the same question that the 5 honorable judges in Bachan Singh's case asked. The answer had to be the option of life had not unquestionably foreclosed because of these mitigating circumstances. circumstances of the crime versus the circumstances of the criminal did not justify the imposition of the rarest of rare rule against him. At least there should have been a discussion on that. Each of these mitigating, aggravating circumstances should be made standalone circumstances, and there should have been a discussion. I can understand a position where you don't agree with me, where you say that we believe these are the aggravating, these are the mitigating circumstances, both the crime and the criminal, and then at the end of a discussion, you say that the option of life has been unquestionably foremost. Where did they do it? One paragraph, one measly paragraph is all we got. That's the value of life in our country. So it is my respectful submission, I am not before the Supreme Court, but I would say that to them, that this judgment is per incurium. We've hanged the man, nothing can be done, but they did not follow the directives of Bachan Singh's case while proceeding with the execution of Yakub Memon. They did not even follow the directives of Shatrughan Chauhan's case, where Yakub's own mercy plea came to the President on the 29th of July. The earlier mercy plea, which was not authorized by Yakub, was given by his brother. Surely the Indian state is compassionate enough, has a broader heart, to give the man 14 days. But 14 days is all that was asked in that midnight hearing. Even that was denied. To my mind, it was a travesty of justice. To your minds, it may not be. But that's the whole idea of a debate. That's the whole idea of a discussion. I am not converting any of you to my position. I am just showing you the progress of the law. And I am saying that in my respectful opinion, Yakub Memon's execution was contrary to the law laid down by the Supreme Court in 1980 in Bachan Singh's case. Everybody's woken up at 2:30, probably cursing the lot of us, but it's okay. It's all right. A man's life was at stake. Sometimes you need to do justice at 3 o'clock in the morning. What was the big deal the media made out of it? If you don't do justice during the day, you might have to do it during the night. Now that's fine. And we are not going to be slavish about it and say, oh, thank you, your lordships, for doing this. It's your bloody job. You have to come and do it. You have to uphold the Constitution of India. You didn't, but that's a separate issue. But you still need to be woken up. So the idea being, there was a strategy there. And the strategy was, we know we're losing. We know he's dying. But we're going to make it as difficult as possible for every death sentence victim to be executed from here on. And if it means we wake you up, we will wake you up every time. And that should be the essence and substance of the law. As students of the law, you may be a little disconnected with what is happening outside. But as an officer of the court, I am not disconnected. I don't not value the lives lost in the blast, because that's the other horrible correlation that people make. Closure. I said it was loathsome. I continue to say it's loathsome. There is no such thing as closure. I am a victim of a violent crime. I am telling you there's no such thing as closure. Certainly the judiciary will not give me closure. Closure is an intrinsically private process where you grapple with your own emotions and you decide to move on, and sometimes you can't move on. Executing a man will not give me closure. However, as officers of the law and as students of the law, what we expect from our system is that the law is scrupulously followed. We don't expect apologies of this kind. Follow the law. And if at the end of it you feel that this man deserves the death sentence, do so. After all, it exists in our statute. But don't give me one paragraph. And then don't tell me I woke up in the night for you. That is just not good enough. And therefore, The 30th of July, to my mind, was a dark day in India's judiciary. Did the world get better on the 31st because a man had got executed? Did the victims get closure on the 31st? I'm not belittling what they went through. That was a horrible, horrible crime. But as a state, and that's the larger debate for death sentence, can you parcel out feelings of revenge? Can you, as somebody wrote, and it's very beautifully written, can you outsource revenge? How does an execution by the state become legal? Under which logic? But that's a larger debate, and for which I'll bring Yug Chaudhary here to speak, because he can speak on that much better than I do, and he will cry also before you. But that's not what I'm trying to show here. My intent here was to show you the evolution of the law and how it was not followed in this latest case. My intent has not been, I am unapologetically anti-death penalty, but that's my problem. It needn't be yours. I hope one day you will also fine-tune your thought processes and come to that intellectual position. I can't impose that position on you. But I'm saying, so long as death penalty exists on our statute book, we must at least respect the law of the land, which has been pronounced by larger benches of the Supreme Court. Yeah, my speech is over. Yeah, tell me. Death sentence? No. Are you asking the wrong person?
Why following the letter of the law?
Sorry? No, if you, no, then you're asking mixing up choices, right? So long as the death sentence exists as an option, why do you think I went through, my throat is gone, why do you think I've gone through the effort of reading Bachan Singh's case? They recognize, they upheld they said within the constitutional framework, death penalty is not unconstitutional. That's the law, and as an officer of the court, I totally and completely bow to that position. But they said, essentially they said, we will make it very difficult for you to routinely execute. Right? And they gave us very illustrative, broad parameters, but they told us what steps to cross. My opposition to the present cases have been that the Supreme Court, you might validly come to the same conclusion at the end of it, but you did not go through the processes which Bachan Singh asked you to. That's my limited argument to it. But again, how can I give an illustration unless every case depends on facts? Those illustrations must, so read Bachan Singh. They're giving illustrative examples of mitigating circumstances of the crime, aggravating circumstances of the crime. They're giving examples of mitigating circumstances of the offender, aggravating circumstances of the offender, and they are saying that you must determinately come to the conclusion that the option for life is unquestionably foreclosed, that there is no way this criminal can be reformed. And there are other judgments which I read which said, we don't care a damn about public opinion, that should never enter the sentencing formulation. Right? So, whether it's just, now I understand what's going through your mind, but whether it falls within the judge-made formulation, these judgments are not there in the Constitution, these are not part of the statute, these are judicial interpretations. Whether it falls within that or not, I am world, the United States of America, it is so irrational. It is so completely irrational. We are leaps and heads and shoulders ahead of that country. Thank God for that, you know. All of you thinking America is a great land, it isn't. Actually, its judiciary stinks. But the fact is that we need to now take this debate to the next level. We can't talk like Arnav Goswami or whoever else comes on TV. We, as students of the law, have to look at it differently. Prejudice is not something we get the privilege of keeping in our hearts. Certainly, if you're practicing criminal law, prejudice goes out of the window the minute you decide to sign a wakalatnama for an offender. We deal with facts, we deal with evidence, we deal with the supremacy of the law. And that's all we want to be followed. So if you look at it internationally, we are not grave offenders. There are graver offenders than us on a much larger scale. In fact, the application of the death sentence in India has been far and few between. And that's solely because we have a judiciary which has by and large followed the law. But even within that, the constraints of that situation, there have been errors. And anyone who says that we can't critique Supreme Court judgment should first be executed. Because it is our constitutional right to critique Supreme Court judgments. How else will law evolve in the future? How else will we reach a jurisprudence which is just and fair? So, it is our constitutional right to do this critique. And what are we doing? We are saying you're not following your own law, which the Supreme Court does on a daily basis. It doesn't follow its own law. But in this particular case, because the consequences are so stark and so irrevocable, therefore, the need to educate everybody that this is the law of the land. Now, till a 6-member, 7-member, 8-member bench overturns Bachan Singh, it's possible they do it. Bachan Singh continues to occupy the space. So, all I need to answer is, did you fulfill the tests of Bachan Singh? If you didn't, it was wrong, it was illegal, it was a sad day. 3 a.m. notwithstanding. Okay? Yeah. No, I don't think he was innocent. But then again, it's my opinion. Who the hell cares for my opinion? I think he may have had some peripheral role. And this you can only say from... see, there's another thing, and that was part of my last talk of the day. You know, when you become lawyers, and when you become criminal lawyers, you learn to separate fact from fiction. What you hear outside very often is fiction. What you read is fact. What you read is evidence. What you read is proof, right? When you talk to Yakub's own lawyers, and I wasn't his lawyer, when you talk to his own trial court lawyers, Satish Mana Shinde and others, all of them say, in any other case, in any other world, Yakub would have been acquitted because the evidence just didn't add up. I have to trust that. I didn't do that trial. I didn't have the opportunity to look at the evidence minutely, as they did, right? So, they may have been, I'm not discounting the possibility that there may have been some evidence against him. May have been. So that's why he was convicted. We're not talking about conviction. We're not even talking about guilt or innocence. So let's call him guilty for the time being, if that makes us feel better, because our collective consciousness is such a fragile thing. We need to feel better all the time. So let's hold him guilty. Let's bring closure. He is guilty of the crime. I am only asking about the next step. That is of sentencing has nothing to do with conviction. He was punished, adequately punished. Punish him for life. Was the nature of his crime versus the nature of the criminal, was it of the nature that required you to invoke the rarest of rare formulation, is the only question we are asking. So in response to your question, do you think he was innocent? He was convicted. No, I mean, right up till the Supreme Court, the conviction order did not get overturned. And I don't think anybody challenged that after a point. So let's take it. He was guilty. In whatever form, in whatever be the link, he committed some offense. But was it necessary to execute him, is the only question.
Don't do anything are as guilty as the ones who committed the offenses.
Well, in which case? I mean, you'll have to be specific here.
It's just a case of reading from my criminal law class.
Yes.
In that, the judge mentioned that even if you just had a peripheral role, you would just as much.
Well, it actually depends on what that peripheral role is. There have been aberrations of judgment, but again, it depends on what that peripheral role is. Obviously, if you're just an innocent bystander, you can't be held guilty of a crime. But I can't put it past the Supreme Court for having made a comment like that, because the Supreme Court is the Supreme Court. It might have made that comment. But the essence of criminal law is that you have to prove involvement, either through a chain of circumstances or through direct evidence. And if you're unable to do that, then you suffer. The Supreme Court itself has said it. They just have to read their own judgments. If they're lazy, what can I do? We don't need to challenge it. These judgments, these two-member benches are all per incuria. When there is a Constitution bench judgment which determines the issue once and for all, you don't have to use these words. Collective consciousness has never been part of Bachan Singh's case. And if you really feel that needs to be revised, send it to a 7-member bench and let's see how you revise it. Right? You can't do it arbitrarily like this. The Supreme Court, more than any other court of the land, must not be accused of arbitrariness. Anything else? Yeah.
Ma'am, while I agree that it's not possible to get closure overnight, the way you put it, however, the larger implication of your argument is to deny any role to retribution in sentencing policy.
Yes.
But don't you think that some amount of retribution in some form has to be taken into account, and why not?
Retribution and sentencing. Why is it that in state cases, the complainant has no independent right of audience? Why is it the state cases are conducted by public prosecutors and not by counsels of complainant? Why is it that evidence is led by the state and not directed by the complainant? There has to be a level of neutrality between the victim. I can understand a victim losing his or her head perfectly. I'm not an inhuman person, I'm a nice person, okay? Don't get me wrong. I totally get what victims go through. I totally get it. But in the province of the law, and you are law students, you must know this better than your mothers and brothers and sisters and whoever else. I can understand them saying that victims must get closure. But we can't say it. And that's not a determining factor when it comes to determining sentencing. Our entire jurisprudence is based on a division between the powers. I mean, it's only now that victims occasionally get a right of audience. Traditional Indian criminal jurisprudence has been state versus so-and-so. Because it's expected that the state does not react with the same level of emotion that a victim will react with, and therefore color the judgment. Of course, if you have a prosecutor like Ujjwal Nigam, that distinction goes away. Because he's worse than the victim. Right? But, by and large, any international standards of sentencing, if you were to look at, retribution, revenge are not factors that are ever considered for purposes of sentencing. It's always reformative. Now you will ask, in a country as large as ours, is fiscal reform very needed? That's true. But we don't even make an attempt. dental clinics, and every day, you know, prisoners are sent, they sit and they work with them, they're doing minor surgeries, they're doing things. Surely that counts for something. Now, ultimately, you don't want to look at prisons as people we don't want to deal with. They're human beings. They were once part of us. They've committed terrible, unspeakable crimes. But when we can't give life, I'm sorry, I'm not religious, so this is not a religious argument, but when we can't give life, can a state sponsor the taking away of life? It's a hugely moral debate. It's complex. There are no easy answers. The rights of victims are rights which must be considered. After all, what then will constitute rarest of rare? It's easy to say that public opinion doesn't form part of it, but you will look at it. So if one man is accused of killing 250 people, you will do it. But politically, also, there are answers to it. 93 happened because of the riots of 92. 92 riots happened because of the demolition of the Babri Masjid. Because they were not punished. Why were they not punished? Because the perpetrators of the 84 riots were never punished. You see, there is a long history in this country of people allowing riots to take place, of no punishments. How many people were punished in 84? Nobody was asked. How many people were punished in 92? There are 3 recorded convictions of 7 years each. Where 1,000 people died in North India, 700 in Mumbai. Largely a one. So you also have to look at it. You can't talk of closure of one set of victims and not closure of another set of victims. That's also a complicated debate. So all I'm asking you as law students to do is to open your minds to possibilities that you've not thought of before. To areas of human pain that you've not addressed before. I think we will have closure if we close the death penalty debate. Right? And I don't think it either acts as a deterrent. That's statistically proved. It doesn't act as a deterrent. The certainty of punishment acts as a deterrent, not the severity of punishment. So if it doesn't act as a deterrent, this is the age of suicide bombers. They will kill themselves anyway. If it doesn't act as a deterrent, what are we doing? We're actually apologizing to law enforcement agencies who never do their job. Shoddy investigations. You are unable to unearth the larger conspiracies, but you will kill one man and the nation is happy. That's not necessarily reflective of the soul of this country. And I'll end this. I just happened to read this yesterday in the context of another case. And that was way back in 1986. It had nothing to do with death penalty. It's a beautiful, beautiful judgment by O. Chinnappa Reddy. It will never be written in today's time. It was called Bijoy Emmanuel versus State of Kerala. Can you imagine the far-reaching impact of that judgment? That 3 children belonging to the Jehovah Witness faith stand up when the national anthem is being sung, but don't sing it. And for the Supreme Court to return a finding saying, it's all right, their Article 19 and Article 25 protects them. And the last 3 lines of that judgment, to my mind, represents the soul of this nation, where the Supreme Court said, one last thing. Our past teaches tolerance, our philosophy preaches tolerance, our constitution practices tolerance. Let us not dilute it. Amazing words from an amazing judge, but which will never be part of Dattu Supreme Court. So, therefore, we also, in our own constitutional history, we have judgments of amazing character and soul. We don't have to be defined by the later bloodthirsty judgments. We can be defined by the earlier judgments of the court. Yeah. haven't even gone that far in India. The debate is quite primitive in India still, because we are still talking about Bachan Singh, aggravating, mitigating. We haven't gone beyond that. See, the problem with us is the minute we raise that as an issue, political parties enter the fray, and then it becomes, oh, you are pro-Congress, oh, you're anti-BJP, and then it just enters a very dirty territory, and none of us want to engage with that. But it's a very valid question. How painless is this process? Is that process itself brutal? You know, because in America, with the injection of lethal injection, there are many prisoners who suffer. There are many prisoners or convicts who've actually not been killed, but have gone into one completely palpitative state. Now, we've not done, because this always happens behind closed doors and in secrecy, and that's what we applaud, because nobody wants to see the horrible man hanging. There's not been enough research or debate about hanging as a process itself. So that's very valid, extremely valid, but I don't think there's enough discussion.
All these arguments will stand when we're discussing the substantive legality of death penalty, but given that it's legal in India, and that it's neither deterrent nor is it retributive, and given that it is a purely retributive punishment, then how do we justify the exclusion of the value that it has to the society? Given that, so for example, in the bomb blast, say that there are thousands of victims, people who are dead and their families, how do we justify the exclusion of the value it will have for these people?
Does it have a value for these people is a question I'm asking. Does it have, I mean, you are looking at it from the outside, but does it have a value for these people? I mean, how many people, even amongst the 235 killed in Mumbai, how many of them, and some of them are very poor people, I don't even think they know that Yakub was hung. You know, so there were these representatives who were put in various television studios, but even there, what kind of closure are you talking? I mean, I think it's a very superficial argument if you think that it will actually be a value. Taking someone's life will make me feel better? I mean, tell me that. Ask yourself that question. I am not satisfied that punishment. So, I've been brutalized in a bomb attack. My limbs were scattered. I've gone through hundreds and hundreds of surgeries. And tomorrow you tell me that मैंने उसको टांग दिया. And today I magically feel better? Isn't that a very naive and a very simplistic view of things? Wouldn't it be better if we had a trial which, this is a 1992-93 bomb blast, which at least concluded by 1995? You had a trial which concluded in 2005. You had the Supreme Court appellate process which concluded in 2015. What closure? Whose life? What are we talking about here? So I think the judiciary in this country has to answer many questions. One of it is delay. That how long it takes. Beyond a point, even victims lose interest. They moved on. You only reopen wounds by doing this 20 years later. You don't give them any sense of justice. And, as I said earlier, it is my political and legal belief that the death penalty cannot and must not be based on public opinion. Those two things are completely different. You have to look at it contextually, and you have to address the larger moral questions.
Ma'am, if I have two responses. One, I'm not saying that it can give closure. I'm saying that is it okay for the Supreme Court to exclusively say that this should not be a consideration at all? And secondly, I remember it was a media report that I read that when there was a petition by like some 2,000 people, not 2,000, fewer than that, in Bombay to the Chief Minister saying that please do execute Yakub Memon. So the thing is, I don't know, so I'm from Delhi and I was quite affected by the NLSIU gang. And I think there was a lot of public momentum during the trial of the accused. And I think it does affect the public to the extent that they do feel that justice.
Let me also place it on record that I will again wake them up at 3 o'clock if they try to execute the Nirbhaya gang rape victims. I don't want death penalty on the shoulders of feminists. We are the ones who asked for the change of the law. I participated in the Verma Commission report. I had a great role to play there. I will, and my colleagues will not allow the state to use our pain and throw the death penalty on us. So the opposition is consistent. It's not just for one person. The opposition is principled, and therefore it has to be consistent.
So would you say we need to consider the substantive legality of death penalty and
Ultimately, we have to. Ultimately, that is the only way out. Ultimately, we will have to consider the substantive legality of the death penalty and come to a determinative finding whether it should or should not exist in our statute book. But I'm saying in the interim period, we can't go on executing people without following our own laws. So in the interim, if there is a law, if there is a message loud and clear from Bachan Singh, we have to look into that and we have to give it primacy. That's all I'm saying.
It's quite obvious that if you are affected by a particular incident, you obviously feel that justice should be done to a particular person you are related with. But on one way, justice might be delivered is you feel that the person who is responsible for that action is excluded. But that public opinion cannot supersede the due process which has been envisaged in the Constitution. So when you say public opinion should be considered, it should not be considered as the most important consideration that supersedes the procedure.
Absolutely. And also, is there consistency in this public opinion? I represent 43 young men who were picked up in the middle of the night in a district called Hashimpura near Meerut, shot dead in the middle of the night by members of the police force in Uttar Pradesh and thrown into the Hindon Canal. 28 years later, in March this year, a Delhi court ruled that all the 19 police officers charged with the crime were not found to have committed the crime. Is that justice? 43 families lost their beloved sons, husbands, brothers, and the manner of that crime, the way it was executed. Even today, even a hardcore criminal lawyer like me, you will get shivers up your spine. It was so brutal. And what do we get? We get a slap on our face saying they are all acquitted. So this consistency and this standard and this closure, जब मर्जी होती है closure हो जाता है, जब नहीं होती है तो बाढ़ में जाए, वो कोई बेचारे लोग वहाँ पे हाशिमपुरा, who the hell cares for them, So there is no consistency in the way we apply our laws. There is no consistent closure. There is no consistent feeling for the victims of the crime. So let's reach there. Only then that debate will become valid. Yeah, I think your teachers are getting fed up with me. So what's the time? It's 12. We give a 10-minute break. And the last session is what I love doing here. And that will be the role of a criminal defense lawyer. It will be hugely interactive. I had a slight, not a very interesting session last night in the car, where I was told of many options this young man was considering. While I completely applaud those options, I also want to put it into each one of your heads that maybe it's not such a bad idea if you're not the vice president of the World Bank. And maybe it's just a good idea that you're part of the team that wakes up judiciary at 3 in the morning. We need people like you to come with us, to walk the talk with us, to be part of a legal system. This is a country where civil liberties is denied on a regular basis. You come from privileged backgrounds, you're in this country's best institution with the best facilities. We don't necessarily want to lose you to the World Bank. We want you to remain here and to be part of this dirty, messy system.